Okay, I see we've got a number of folks that have joined us. Welcome. Thank you all very much for being here today. As I mentioned, my name is Tricia Tiafolo Olave, and I supervise our VAWA and U-Visa Pro Bono project here at the National Immigrant Justice Center. I am accompanied by Lisbeth Sanchez and Marissa Labella, who both work on our VAWA and U-Visa Pro Bono project, and Ellen Miller, who manages our pro bono projects here at NIJC. And some of you may have spoken to any one of us in order to register for this training. Regardless who it was, we're all very grateful that you're here today. And without further ado, let's go ahead and get started. I'd like to mention just briefly a little bit about the National Immigrant Justice Center so that you all know the work that we do. And in case you're interested in volunteering for any pro bono cases, this will give you a little snippet of the work that we do. So NIJC has a very unique approach to the work that we do. We provide direct legal services. We have staff that are in-house and meet with clients to prepare cases, but we also have a team dedicated to policy and advocacy. We have a federal litigation project. So with our unique approach, we're doing not only direct legal services, but also policy and advocacy and litigation in order to try to implement change at all levels. We do this work with a huge pro bono network of over 2,000 pro bono attorneys, and that is what allows us to provide services for so many clients. Without your assistance in your pro bono work, we would not be able to serve as many clients as we do. All of our clients are at or below 200% of the federal poverty guidelines. And that is, how we are able to assist clients who cannot afford to pay private attorneys, right? If we come across someone at a consultation who is above that, then we refer them out. So today we're going to talk briefly about the various NIJC pro bono projects. And then Lisbeth is going to give you tips for working with domestic violence clients. So those would be survivors of domestic violence who qualify for VAWA or potentially a U-Visa. Today we're going to focus on VAWA, Violence Against Women Act, but a lot of the same tips are relevant for working with survivors of domestic violence in other contexts. Then I'm going to give you a brief overview of family-based immigration. And the reason we incorporate that into this training is because it helps you understand how VAWA clients fit into the immigration system, okay? Then we're going to talk about how to prepare a VAWA case, and Liz is going to go through the nuts and bolts of putting together a VAWA case. And finally, at the end, we'll give you reference sources and contact information for how to prepare a case, who to reach out to if you have questions, and if we have time, we'll go through some hypotheticals. If you have questions throughout the training, feel free to put them in the chat or ask a question there, and we will attempt to answer the questions as we go along. If we don't get to your question during the training, we will also try to leave time at the end in order to make sure that we answer all of your questions. I do want to mention too, it was on the first slide there, this training is geared towards attorneys and accredited representatives, so folks accredited by the Department of Justice, to provide legal advice and prepare these cases, okay? Now, if you are not an attorney or an accredited rep and you're interested in learning about VAWA, that's fine. You're welcome to attend this training, and hopefully you will find some information that is helpful in recognizing who might be eligible for VAWA. But I do want to caution against the unauthorized practice of law. And so we are not providing this training so that people can file VAWA self-petitions for themselves, or that someone who is not an attorney or an accredited rep would prepare this type of application. It's merely so that you could recognize who might be eligible for VAWA and then refer them to us or to another provider. Okay, back to the NIJC pro bono opportunities. So as you can see here, we have a number of different opportunities, including asylum, which is for folks who are fleeing persecution from their home country. Detention, we have a detention project that represents clients who are detained. Our litigation project files impact litigation cases at the federal level. We do clinics for DACA, that's Deferred Action for Childhood Arrivals, and naturalization for folks who are applying for citizenship. We have a project specifically designed to represent special immigrant juveniles. Those are children who have been abused, abandoned, or neglected. And then our project, the VAWA and U-Visa Pro Bono Project, which represents folks who have been victims of domestic violence or certain qualifying crimes. So our pro bono system is a very well-oiled system. The client contacts us or we find them through outreach, and they come in on intake. Right now, everything is being done telephonically due to COVID, but we do an in-depth screening of the case to determine if they are eligible for any form of immigration relief. So for this type of case, for example, once we've determined that someone is eligible for VAWA, then we provide them with a list of the requirements in order to apply for VAWA. And once they have everything ready, that is when we will sign a pro bono retainer with them and prepare a case referral packet to have ready for a volunteer attorney, okay? So once the case is accepted, that's when we put everything together and begin to look for a pro bono placement. Once you accept the case, we remain of counsel and provide technical assistance throughout the life of the case, okay? We'll do document review before you file anything. It always helps to have another set of eyes look at it, but also just to make sure that there haven't been any changes in the law or nothing that would affect the filing of the case. We ask that you remain of counsel throughout the life of the case. And again, you can come to us with any questions during that time. There are responsibilities in these various roles. So we provide the outreach and training to all of the pro bono attorneys and also in the community, whether it be to domestic violence shelters or hospitals, schools, various places in the community. We prepare that case referral packet for you. And then throughout the life of the case, we will continue to provide that technical support, reviewing drafts, discussing case strategy, and responding to questions that the client may have. We can provide you with samples, policy updates, and malpractice insurance. And as I mentioned, we remain of counsel throughout the life of the case also. So it's very important that we have communication with you throughout the case so that we know what has been filed and what is going on with the case. As a pro bono attorney, you must do a conflicts check to make sure that there are no conflicts before taking on the case. And then we ask that once you have accepted a case, you would schedule a client meeting within the first few weeks. And obviously right now that can all be done remotely. We do ask that you begin preparing the case and ideally file the case within about 8 to 12 weeks, okay? If that's not going to be possible, we would want you to communicate that with us and the client. We ask that you represent the client for the duration of the case. If it's necessary to provide any translators or interpretation, that is your responsibility. We can assist in providing some options for volunteer interpreters if necessary. Oftentimes, there are support staff at the law firms that are willing and interested to provide interpretation services if necessary. You need to keep us informed of any filing dates, requests for evidence, case decisions, or any concerns that arise in the case. If the client suddenly has a change in their status, their marital status, or they're arrested, or something comes up, it's important that you communicate that with us. And then of course the client has responsibilities to you and to us to always be honest and truthful in their communication. And that may take time to build trust and safety, of course, but it is important that they're not withholding information that is relevant to their case or lying to you. We ask that the clients notify you of any changes in their circumstances, including changes of address that would need to be updated with USCIS. So that's it for the NIJC pro bono projects. I don't see any questions so far, so I'm going to go ahead and turn it over to Liz, who can begin discussing tips for working with clients who are survivors of domestic violence.
Thanks, Trisha. Hi, everyone. As Trisha mentioned, my name is Lizbeth Sanchez. I use she, her pronouns. I'm the VAWA U-Visa Pro Bono Project Coordinator. So I work alongside Trisha and Marissa LaBella to support our pro bono attorneys throughout the life of a case. In this case would be a VAWA case. So my job is to make sure that our cases are placed with awesome pro bono representation and to help pro bono attorneys with any technical questions they may have as they prepare a case and continue to provide that support until a final decision is received. So please feel free to ask questions as they come up throughout this presentation. All right, so before diving into the topic of domestic violence, I'd like for all of us to take a second to answer a few poll questions that I'll be pulling up right now. There are 3 polls, and so you'll only have a few seconds to answer. Don't think about it too much. It's not a test. It's just to see, what we all know, what we've heard about in regards to domestic violence, and then we can talk about the answers throughout the presentation. Okay, just a few more seconds. Okay. And the next question. Okay. And one more question. Okay, I'll be closing the polls now. All right, thank you everyone for participating in that. So before we answer any of that, let's dive into this power and control wheel we have here. And before doing that, let's define domestic violence. So domestic violence can be defined as a pattern of physical and psychological abuse used by one person to exert power and control over another person. And that can be in the context of dating, a family or household relationship. And so throughout this presentation, I will mostly be referencing to relationship abuse because this is what we often see in VAWA cases. And so going to our first poll question, what was the question? Domestic violence happens more often in immigrant communities, right? So let's get this out of the way. This is false. It's a huge misconception. Domestic violence, unfortunately, is an issue that exists amongst all races, genders, sexual orientations, social economic status, etc. For example, men can face domestic violence. Abuse can also exist in non-heterosexual relationships. And technically, it's about underreporting. And there's many reasons why people experiencing abuse might not speak out and seek help. And so based on the answers that people gave, it looks like, I'll share it. For this question, there seems to be a 50% response that domestic violence happens more often in immigrant communities, with that being true. And then 41% saying it was false. And again, this is a misconception, and this is why we're here, so that we can, learn a little bit more about what this means and debunk some of these misconceptions that we often hear about. Okay, so now let's talk about the tactics used by abusers in situations of domestic violence by looking at this power and control wheel. So both sexual assault and domestic violence are about power and control. We know that an abuser asserts their power and control over their partner, their spouse, or a child in physical and non-physical forms of abuse. Right? And so we as advocates like to reference this wheel to show the overall pattern of abuse that an abuser uses to maintain control over someone. And some ways that an abuser may exert power and control is through economic means, intimidation, isolation, just to name a few. We've heard many times how survivors of domestic violence felt trapped in their abusive relationship because their spouse or their partner controlled all of the money, and if they did have a job, any money that they made went directly to the abuser. And we hear about how the survivor was isolated by not being allowed to see their family or friends, and their partner would just not allow it, or they would just get very jealous. Other acts of abuse can include emotional and verbal abuse, such as insults at home or in public, threats to take away children or to hurt them, and threats or acts of violence against animals or objects in order to instill fear. And so sometimes the most severe forms of violence that an abuser can exert over someone will leave no trace for anyone to see. And so this is something that abusers tactfully use more often, because if the survivor were to speak out, then no one might believe them, and it might be difficult for the survivor to show the abuse. You can go on to the next slide. And so here we have the cycle of abuse. This is something to think about because we commonly see this when working with survivors of domestic violence. We often see that there's a cycle of abuse. We may ask a survivor of domestic violence how their relationship was in the beginning, because oftentimes relationships start with love and kindness and essentially the honeymoon phase, where things feel like rainbows and sunshine. And so this phase might not last very long. We often see it move into the tension building phase that we see in this cycle, where there might not be any obvious violence. And I say obvious violence because abuse is abuse no matter whether it's physical, whether it's verbal or emotional. But what happens in the tension building phase is that the abuser may slowly start isolating their partner and start controlling the financials. These are some red flags to watch out for. An abuser might say that they can't go out, their partner can't go out to see their friends and family because they don't trust them, or they might constantly be checking on their partner's phone and accuse them of cheating. And so these forms of abuse are not visible, but significant because they can imprison an individual in a relationship. And oftentimes, all these things can lead to an explosion where physical violence can occur. And that's not always the case in every situation of domestic violence. That might never happen, but we do see this commonly. After an explosion, the abuser might try to patch things up by asking for forgiveness, by blaming their partner for what happened, and maybe try to be romantic. This might work because the person experiencing the abuse starts to believe them. The violence is then repeated through this cycle. And what ends up happening is that the honeymoon phase at some point starts disappearing over time. And there might be a lot of denial and self-blame coming from the survivor. And again, it's not in every case that there's this continuous victimization over many years, but it's something that we see commonly. And so some of our clients that we work with have been able to leave their abuser, and they might be living in a domestic violence shelter or with family or friends. Others might continue living with their abusers throughout the process of applying for immigration relief, particularly where there are children involved. So everyone's situation will be different, but it's helpful to keep these things in mind in order to provide the best possible representation as their pro bono attorney. Going to our second poll question, where I asked you all to answer whether you thought it was true or false that if a person is really being abused, it's just easy to leave. So I'm going to share what some of these results were. And so 19% said that this was true. When a person abuses another, it's because they can't control, oh, I'm sorry. That was the wrong poll. Okay, here it is. If a person is really being abused, it is easy to just leave. 100% said false, and that's true. Leaving can be more complicated than it seems. And so leaving is often the most dangerous time for someone who has been abused, because when a victim leaves, they are taking control and threatening their abuser's power, which could cause the abuser to retaliate in very destructive ways. And so leaving could sometimes mean death to somebody who is in a situation like this. And that's why it's important to refrain from giving your opinion to someone who is experiencing domestic violence and they don't want to leave. That's their choice. Who better knows their abuser other than the person living with them and experiencing the abuse? And so we're just here to support them, support their decisions, and provide any other resources that they might need once they are ready to leave, if that's what they decide to do. Okay, we can move on to the next slide. So NIJC's clients come from a wide range of different cultural, religious, and socioeconomic backgrounds. The clients that we serve face many challenges with respect to their immigration status, but also face other barriers that are often not talked about in regards to trying to access legal counsel for immigration relief, as well as, in this case, for VAWA, break the cycle of abuse. And so some of these barriers can include, but are not limited to, language limitations, feelings of extreme isolation, right? Feeling like they're alone and that no one might understand or believe them. Cultural ideas of family shame and honor. This can stem from their home country and also trying to adapt to a new culture and systems here in the United States. And this can also be linked to how domestic violence or relationship abuse is a topic that is oftentimes taboo. Close-knit communities, which can be a great asset, but can also sometimes make it very difficult to seek help if experiencing domestic violence. For example, there might be a common belief that the family is the only appropriate forum for dealing with such problems. In certain instances, outside interference is not encouraged or accepted, or seen as shameful. And so it's important to note that there's a general mistrust as well with law enforcement agencies, medical and criminal justice systems, especially in immigrant communities, because they've been failed essentially by these systems. There's also the role of religion that can play as a barrier and also as an asset to immigrants facing domestic violence and accessing legal counsel. And so, as we said previously, domestic violence is not unique to a particular community, race, or culture. And so while cultural differences must be considered, assumptions should never be made about how someone's culture is, for example, in her culture, domestic violence is accepted as normal behavior. Saying something like this is completely false and not right. Or in her culture, women are passive. So assumptions like this should never be made. Okay, next slide here. Another method of control and power that comes up very often, especially in VAWA cases, is where the abuser uses the survivor's fear related to their immigration status. And so an example of this is when the abuser threatens to contact immigration authorities to notify them of their spouse's undocumented status. We have heard of instances of where an abuser who is a US citizen has gotten in contact with USCIS and tells them that their spouse is a fraud and only got married to them because they wanted to get a green card. We have also seen situations where the abuser files an I-130, a family-based petition, or any other type of application, and later withdraws it to use for manipulation and control. So this is just another layer on top of all the barriers that immigrants may face within a situation of domestic violence. And so before moving on, I'd like to see if there's any questions. If not, turn it back to Tricia.
Somebody does have their hand raised. Let me just, well, let's see. I'm trying to unmute, but it doesn't seem like it's allowing me to do that. But I'd encourage you to go ahead and type your question in and into the control panel, and we'll attempt to answer it that way. Okay. So as soon as we get that question in, we will we'll try to address it. Please, if anybody else has questions, go ahead and type them in. I see somebody else has their hand raised. Let's see here. Yeah, Daniela, I'm sorry, I can't unmute you. It says self-muted. So if you can just go ahead and type in your question, we'll try to answer it. Thank you, Liz, for going through those tips in working with survivors of domestic violence. And you know, as you're working on a VAWA case, a VAWA pro bono case with us, as issues come up or questions come up, please reach out to us. We don't expect you to be experts on day one, right? This is a learning experience throughout the case. And so we are here to provide the support that we can. Now I'm going to shift gears and begin talking a bit about family-based immigration. So for those of you that have not done immigration law before, that's totally fine. This is not an intense, extensive training on family-based immigration, but it's going to be just a broad overview to help you understand the family-based immigration system, okay? So a U.S. citizen can be someone who is born here, a natural-born citizen, or it can be someone who has applied for naturalization and obtained citizenship that way. Lawful permanent resident, otherwise known as an LPR, is someone who has their green card and is here legally allowed to live and work here in the United States. Many people who have been green card holders are eligible to apply for citizenship after about 5 years. Some can actually apply after 3 years, and some people will not be eligible for citizenship if they have certain bars to citizenship. Immigrants, that's a very broad term, and it can refer to asylees, folks who are applying for asylum, refugees who have been granted refugee status before coming to the United States. An immigrant is generally, though, someone who is immigrating here long-term, okay? And a non-immigrant, on the contrary, is someone who is here on a temporary status. So the difference between an immigrant visa and a non-immigrant visa would be that a non-immigrant visa is a temporary visa for someone such as a tourist or a student. The U visa is actually a non-immigrant visa. An immigrant visa, on the other hand, is a green card. So that's for someone who is intending to stay here long-term. And then undocumented immigrants refers to folks who are here without legal status, okay? And so an undocumented immigrant could be someone who has entered the country without inspection and is here without status. It could also be someone who has overstayed their visa, or someone who entered the country with false documents. So in family-based immigration, U.S. citizens and lawful permanent residents or green card holders have the ability to file a family petition for certain family members. And it's a two-step process. The person with status is the petitioner. They're the ones that file the petition. So they file generally an I-130 petition for their family member. And then the second step of the process is that the beneficiary, the person who is looking for the benefit, files an application for their green card. So that first step, the Form I-130 petition, a U.S. citizen can petition for their parents, their spouse, their children, and the children can be unmarried and under 21, or they can actually be over 21 and married or unmarried. And then U.S. citizens can also petition for their siblings. A permanent resident, on the other hand, can only petition for their spouse and unmarried children under 21 or over 21. So it's two different categories there. But a permanent resident cannot petition for any children who are married, and they cannot petition for parents or siblings. So it's a much more limited group of people that a permanent resident can petition for. In immigration law, there's a distinction between children who are under 21, they're referred to as children, and if they're over 21, they are called sons and daughters. Okay, so just to help understand that distinction. And they, as you'll see in bold there on the bottom, the US citizen or the permanent resident must file the petition. So if you have a situation where the couple agrees that they're going to go through this family-based immigration case, but the US citizen or permanent resident petitioner changes their mind or just doesn't want to bother, there's really not much that the beneficiary can do, that the other spouse can do. In this process, it gets complicated because there is this extensive preference system. So I'm going to try to explain it in very simple terms. But the fastest group of people that can go through this process are what are called immediate relatives. Immediate relatives do not have to wait. They can immediately file that petition and then apply for the green card process. Okay, so the immediate relatives would include the spouse, children under 21 and unmarried of a US citizen, and the parents of a US citizen. Those are the immediate relatives, and that's the fastest group. They can go immediately from filing that I-130 petition to the green card application. Everybody else is in the preference category, depending on the relationship between the petitioner and the beneficiary and what country they are immigrating from. So the priority date becomes very important when you're in that preference system. So when someone files an I-130 petition for their relative, they are assigned what's called a priority date, and that priority date is usually around the same time as the date that that petition is received from immigration. So if, for example, I filed an I-130 petition for my family member today, there will be a priority date right around January 28th, 2021. And that priority date is my relative's spot in line, essentially. And they will not be able to proceed with step 2 of applying for the green card application until that spot in line is called up in the queue, right? And so immigration, actually the Department of State, issues what's called a visa bulletin every month with dates listed on it. And when the priority date becomes current, that is when my family member can move on to step 2 and apply for their green card. Depending on the preference category, some folks have to wait over 10 years to be able to proceed with step 2. So I mentioned immediate relatives. You'll see that here, the spouses of citizens, children under 21 and unmarried of citizens, and parents of citizens. Those are immediate relatives. Everybody else goes into this preference system, and here are the different categories. So first preference are the unmarried sons and daughters of US citizen. let's skip the second category for a second and go down to the third category. That's the married sons and daughters of US citizen. And the fourth preference are the brothers and sisters of US citizen, right? So if I'm a US citizen, I could file a petition for my spouse, and that would be an immediate relative. If I have a child who's unmarried and under 21, that's also an immediate relative. But if I have another child who's over 21, they are in the first preference category. If I have another child who is married, they're in the third preference category. And if I want to file a petition for my brother or sister, they are in the fourth preference category. On the other hand, if I'm a permanent resident and I want to file some family petitions, they are going to be in the second preference category. There's 2A, that would be a spouse and any minor children who are unmarried under 21. And then 2B are the sons and daughters who are unmarried but over 21. So here is the visa bulletin from February of 2021. The visa bulletin comes out around halfway through the month prior. And so this is hot off the presses. Here you can see the different categories on the left-hand side. So F1 is the first preference, 2A is there, 2B, 3, and 4. And so immediate relatives aren't on here because they immediately go on to step 2 of applying for the green card. They don't have to wait for a priority date. In the second line there, the F2A category, you see the letter C across the board. That means current. That means that the F2A category is current. So if your relative is in that 2A category, right? If I'm a permanent resident and I'm filing a petition for my spouse or unmarried children under 21, they are in this 2A category. And right now, during the month of February 2021, they can immediately proceed to step 2 of filing the green card application. I can't guarantee that that category will stay current in March of 2021. So if you have somebody in this situation, it's in their best interest to try to file before the end of February. But if we look at some of these other categories, right, you can see, for example, that there are separate columns for China, India, Mexico, and the Philippines. So if your client or your family member is immigrating from one of those 4 countries, the priority date could be different. That's because we have more immigrants from those countries. And so there's a complicated formula that goes into the priority dates and when they become current. But you'll see, for example, if I'm a US citizen and I'm petitioning for a brother or sister from the Philippines, we're barely looking at cases from February of 2002. If my brother or sister is from Mexico, they're at cases from July 1998, right? So that's a long time that the person has been waiting and they still have not been able to proceed to actually applying for the green card. That means that folks from August of 1998 are still waiting for their priority date to become current and to be able to proceed with the next step of applying for the green card. So we're talking, 23 years here, just to give you an idea of what this process looks for. So once an individual has an approved I-130 petition and the priority date is current, they may qualify to adjust their status. That would be filing Form I-485 to apply for the green card here in the United States. Not everybody qualifies for adjustment of status. So if someone does not qualify to apply for the green card in the United States, they would need to consular process in their home country. So I'm going to pause there for just a second and take a look and see if we have any questions. I am not seeing any right now, so I'm just going to keep going along. But please, I would encourage you to go ahead and put your questions in the chat. Okay, let's see it. I'm going to try this unmuting again to see. It looks like we have a question from Delik. If you want to go ahead, I tried to unmute you. I think you can ask your question.
Sorry, can you hear me?
Yes.
Okay, great. I had written in the chat, but then it didn't make sense. But I was wondering, does the priority date change for an unmarried son or daughter once they get married if the petition has already been filed?
That is an excellent question. So if the petition has already been filed and you said an unmarried son or daughter who then becomes married, right?
Correct.
Okay, so I'm just going to back up my slides here so that everybody knows what we're talking about. So we're looking at first this first group here, right? They're in the first preference category because it, for example, I'm a US citizen petitioning for my son or daughter who's over 21, but they're unmarried. And then they get married, they move down to the third preference category. So yes, they would then move to the different category based on whatever country they're from. So if they're not from China, India, Mexico, or the Philippines, the priority date that was current would be September 15th, 2014. But then once they're married, that priority date is significantly further back, about 6 years. And so say, for example, that petition was filed in September of 2014. Well, if they were still unmarried, they would be able to proceed with step 2. But if they're now married, they're going to have to wait about another 6 more years before that priority date becomes current. And when I say waiting about 6 years, obviously that's an estimate. We can never guarantee how long the priority dates are going to take to become current. It's just an estimate based on where they're at right now. Because if for the third preference, if they're looking at cases from July 2008 right now, they have to get through the rest of the cases from 08, 09, 2010, 11, 13, and 14 until they would get to the client's current priority date. Does that answer your question?
It does, thank you.
Sure. So another thing that I'd like to point out with that is, if we go back, we talked about how permanent residents cannot petition for children who are married, right? And so if I am a permanent resident and my child is unmarried, or my son or daughter is unmarried, and then they get married, they would then lose out on that I-130 petition, and that petition essentially dies when they get married. And so it's really important that clients or family members understand this before they get married. They could, of course, if they get divorced, refile, or if the petitioner becomes a US citizen, right, then that unmarried son or daughter would move into the first preference category, and then they could get married and move into the third preference category. But it is important that people understand all of this, because you would hate for somebody to be waiting 10 plus years and then lose their petition because they got married. Unless, of course, they choose to do that, and maybe they can go through the process with their new spouse.
Trisha, there's a question in the chat that asks, so people from 1998, parentheses F1 Mexico, were spouses of permanent residents from Mexico and have been waiting for 22 years?
So the first preference is for an unmarried son or daughter of a US citizen. So if we are looking at this, the February 2021 visa bulletin, and we're looking right here, first preference from Mexico, that means that the priority date that is current for sons and daughters of a US citizen who are unmarried is January 2nd, 1998. So yes, that means that if a US citizen petitioned for their adult son or daughter who's unmarried in, for example, February of 1998, they would still be waiting for that priority date to become current. So I hope that answers that question. If not, please follow up. Please either raise your hand, or we'll follow up with a question. I see that there are some more questions, and I will try to answer more to when I'm not speaking, but Liz, do you have any others that?
No, that's it.
Okay, cool. I do, yeah, I see. Thank you. Now I see these questions. Okay. Oh, and yes, I see that Beth asked a question and Liz answered. Thank you so much. Okay, so I'm going to move along. Now that you have a brief understanding of the family immigration process, we can go into the specifics of VAWA, the Violence Against Women Act, okay? And the reason I find it very helpful to give that background first is because the Violence Against Women Act fits into immigration law in that family-based immigration system, okay? So the Violence Against Women Act is actually a very large law that was signed by President Clinton back in 1994, and it's a larger crime bill that addresses domestic violence, sexual assault, and stalking. The immigration components have been amended multiple times over the years, and there are special provisions for immigrants that have suffered domestic violence that allow someone in that situation to apply for immigration relief without relying on their abusive spouse. Okay, so as I mentioned previously, in that family-based immigration system, the petitioner holds all of the control. If the US citizen or permanent resident petitioner says, you know what, I changed my mind, I'm not going to file this petition for you anymore, or I'm going to abandon this petition for you, or I am going to notify the authorities that you're here undocumented, then it really puts the beneficiary, the person without status, in a predicament, right? A very precarious situation, and there's not a lot that they can do. Well, fortunately for VAWA, it allows a survivor of domestic violence to file a petition, and that petition can take the place of the family petition that the US citizen or permanent resident could have or should have filed. Okay, so who is eligible to self-petition under VAWA? Well, the most common group of people that we see are the abused spouses of US citizen or permanent resident. Okay, so if my spouse is US citizen or permanent resident and I've been a victim of domestic violence, I can file a VAWA self-petition. I could also do so if I have not been abused, but my children have been abused, and they don't necessarily need to be children of the abuser. Okay, children can also apply for VAWA. Okay, they must meet the definition of a child under the Immigration and Nationality Act, which is generally being unmarried and under 21, and that would be the child of a US citizen or permanent resident. Now, for immigration purposes, it would only make sense for a child to file for VAWA if that child does in fact need immigration legal status, right? So if the child was born here in the United States and they're a US citizen, then they would not need to file for VAWA. The children who qualify for VAWA and apply can actually file up until they turn 25 if they can prove that the abuse was one central reason for their delay in filing before they turn 21, right? Because we've already determined that in order to be considered a child under immigration law, you need to be unmarried and under 21. Well, 21 is, I mean, a lot of young folks don't have a grasp on their immigration status before they turn 21. And if you didn't know that VAWA existed, or that you didn't have legal status, or you were a victim of abuse and that prevented you from being able to file a VAWA self-petition, you can file up until you turn 25. That was an amendment made during the VAWA 2005. And then this fifth category, abused intended spouses, is important because there are unfortunately a number of folks who come to us and they believe that they're married. They went through a marriage ceremony, they have a marriage certificate, and then after the fact, they find out that the abusive partner is actually already married to someone else, which means that their marriage is not valid because bigamy is not legal in the United States. And so if that marriage elsewhere, whether it was here in the United States or in another country, is still a valid marriage, then the second marriage is not valid. And so previously, folks in this situation do not qualify for VAWA, but then with the amendments that took place, intended spouses are now eligible to apply for VAWA. If the VAWA self-petitioner, so the person that you are helping, is the person who has been bigamous and they are the ones that have married multiple people, then that person is not eligible for VAWA. Okay. Abused parents of US citizen children can also apply for VAWA, and this was an amendment in VAWA 2005. So, you know, unfortunately, I think elder abuse has become more common. And so if you have clients who are not necessarily elderly, but whose children are abusive towards them, the children would have to be over 21, because in order to file a petition for your parents, you have to be over 21. But so if the abusive child is over 21 and the parents do not have legal status, they could potentially apply for VAWA. So how do you apply for VAWA, right? It's not quite as simple as just saying I've been a victim of domestic violence. You have to prove a few different elements in order to submit a VAWA self-petition. You have to prove the status of the abuser. So that person has to be a US citizen or permanent resident. And that's because that person, if they did not have immigration status, would not be able to file a family petition for you. So you have to think of this in terms of the family immigration process, right? Is this a relationship that would have or could have been filed a family petition, an I-130 petition by the abusive spouse? If so, then the victim of domestic violence can file a VAWA self-petition, okay? If the abusive spouse did not have legal status, then you would not be eligible to apply for VAWA. And instead, we would look at a possible U visa. You have to prove that the marriage was legal and valid and that it is a good faith marriage, okay? This is a requirement in immigration law whenever you're filing something based on marriage. And you have to look at the intention of the couple at the inception of the marriage, okay? Did they intend to establish a life together? So there's no particular requirement that they have been married for a certain amount of time, but they're going to look at that intention at the inception of the marriage. You have to prove battery or extreme cruelty. So we come across a number of cases that there's no physical abuse, but they do have to then prove extreme cruelty. And Liz is going to go into more specifics. And then you have to prove residency requirements, that they lived together, and there's no requirement for a specific amount of time, but they had to at least live together at some point. And the self-petitioner needs to prove that they're currently here in the United States, or if abroad, there's certain restrictions. Good moral character. The statutory period for good moral character for a VAWA self-petition is the 3 years prior to filing the VAWA self-petition. Okay. So, as I mentioned, how do you prove the marriage component? Well, the validity of the marriage is determined by the jurisdiction where the marriage took place. Okay. So, for example, if your client or family member lives in an area where common law marriage is legal and they are common law married, then that's valid, that's fine. If they live someplace where that's not legal, then you can't use that to count as a valid legal marriage, okay? The exception would be if the marriage violates public policy. So for example, a bigamous situation. So if the clients are from an area where bigamous relationships are valid abroad, we would still have to make a determination of, is that marriage considered valid here where they are living and applying for the VAWA self-petition. Intended spouse, as I already mentioned, so that would be somebody who believes that they are married and they went through a marriage ceremony but then found out that their abusive partner was already married to someone else, okay? Here's the citation from the Code of Federal Regulations. It's at 8 CFR 204.2C19. The key factor in determining whether you can establish good faith marriage is what was the intention at the time of marriage. So there are a few exceptions to the rule that do allow someone to apply for a VAWA self-petition within 2 years. If the abusive spouse was a United States citizen and that abuser dies, then the surviving spouse who's been a victim of domestic violence can apply for VAWA within 2 years of the death of their abuser. If they have gotten divorced, okay, then the the domestic violence survivor can apply for VAWA within 2 years of the date of the divorce being finalized, okay? So we have a lot of people come to us who are working on getting a divorce. Sometimes that takes a while, sometimes it's very fast. It's the date that the divorce is finalized that counts, and then they have 2 years from that date to file their VAWA self-petition. The VAWA self-petitioner cannot remarry before filing their VAWA self-petition, okay? In fact, we would encourage them to wait until the VAWA self-petition is adjudicated. Once that happens, then there's no problem if they go forward with a remarriage. If the abusive spouse was a permanent resident and is deported as a result of the abuse, then the victim of domestic violence can apply for VAWA within 2 years of the date of the deportation, as long as there's a connection between the deportation and the domestic violence. So I think that Liz already addressed the definition of battery or extreme cruelty. It's pretty broad in the Code of Federal Regulations. It's defined as any act or threatened act of violence, including forceful detention, which results or threatens to result in physical or mental injury. And this may include other acts of violence, such as acts that in and of themselves may not initially appear violent, but that are part of an overall pattern. Okay, and that's important because with domestic violence, as Liz was talking about, you know, it's not necessarily going to be one incident, and it's not always going to be that explosion. Sometimes it's years of humiliation, degradation, lowering of someone's self-esteem, and oftentimes clients actually don't recognize that what they've been experiencing for years has been domestic violence until we refer them to counseling and they're able to really recognize what they've been going through. And also keeping in mind that for some folks, if they grew up in a situation of domestic violence, then maybe there was an understanding that this is normal, right? And not realizing that it doesn't have to be this way. Good moral character, as I mentioned, the VAWA self-petitioner has to prove good moral character for the 3 years immediately preceding the application for VAWA. And you can't have any bars to good moral character, which are found at INA section 101F. But there are some exceptions to those bars at INA section 204A1C. So for example, if your client is convicted of a crime that is connected to the abuse, then that could be an exception or something that's waivable for purposes of admissibility or deportability. And then very important with these applications is knowing that the standard of proof is any credible evidence, okay? So imagine if you are fleeing your home in the middle of the night and trying to keep you and your children safe, you aren't going to necessarily have time to gather all of the documentary proof to show that you've been married in good faith or that your spouse has legal status or any of these things. And so sometimes gathering the documentation is not very easy for VAWA cases. We work with our clients to gather enough evidence to put together a solid application, but we also need to remind immigration that the standard is any credible evidence, because sometimes immigration tries to push back and demand more than what they should be asking for. These confidentiality provisions are important because sometimes clients are very fearful of applying for VAWA for fear that their abusive partner will find out, or they're also afraid that the abusive partner is communicating with immigration authorities. And so Section 384 of the Illegal Immigration Reform and Immigrant Responsibility Act prohibits all Department of Justice and Department of Homeland Security employees from providing any information about a self-petitioner to third parties. So we tell our clients, you know, not to notify their abusive partner that they're applying for VAWA so that they don't find out. You know, they really shouldn't find out unless the VAWA self-petitioner tells them, because you and I can't disclose that information due to client confidentiality, and we would recommend that they just don't share that information with somebody who might tell the abuser, so that they don't try to turn around and use that information against them. Similarly, the Department of Homeland Security is prohibited from making any decisions about the removability of someone based solely on information provided by the abuser. So I have seen cases where the abusive spouse has contacted immigration authorities and made claims that are false, like saying she married me just for the papers. All of this is, she's making it up. Fortunately, VAWA self-petitions are adjudicated at the Vermont Service Center, where they have been trained on domestic violence. And so they generally know that those types of claims are part of a pattern of domestic violence. But nonetheless, this Section 384 would prevent a DHS employee from making a decision on the removability of someone based solely on information provided by the abuser. And they would have to give the client the opportunity to respond. Why would somebody want to apply for VAWA? Well, it is on a path towards legal status, right? If your VAWA self-petition is approved, you can get deferred action, which, although it's not really a status, it is a layer of protection against deportation. Once you have deferred action, you are authorized for employment and you can apply for a work permit. So for many of our clients, having that work permit is the biggest gain in being able to provide for themselves and their families. You can include derivative children on a VAWA self-petition. So any children who are unmarried and under 21 can also be included as derivatives. And that can include children who are inside or outside of the United States. And then once the VAWA self-petition is approved, you may be eligible to apply for your green card. Now, depending on if the abusive partner was a US citizen or permanent resident and what that relationship was, will determine if you are immediately eligible to apply for your green card or if you have to wait. So for example, if it is a spouse of a US citizen who is applying for VAWA and they are, once the VAWA is approved, they can immediately apply for adjustment of status because they would be considered an immediate relative. But if it is a spouse of a permanent resident, they would have to wait for that priority date to become current, okay? So let me just make sure that I'm keeping us on time here. Okay, just a couple more slides. In order to apply for the green card, most VAWA self-petitioners will be eligible for adjustment of status. Okay, so there are rare exceptions where a VAWA self-petitioner is not eligible for adjustment of status and would need to consular process. That's not very common though. The other scenario, though, that we do come across sometime is where someone is just simply never going to be eligible for adjustment of status under VAWA unless the laws change, okay? So there are certain things that would prevent someone from being eligible to apply for adjustment of status under VAWA, such as a false claim to US citizenship, okay? But here, we're going to talk briefly about who is eligible to apply for VAWA adjustment of status and how they would do that. So if you have an approved VAWA self-petition, or you're an immediate relative, then you can apply for VAWA adjustment. And if you are an immediate relative, you could actually file the VAWA self-petition at the same time and file what we call a VAWA one-stop application, where you're filing that I-360 petition with the I-485 application for adjustment of status. If you have a priority date from a previously filed I-130 petition by the abusive partner, then you can actually ask immigration to retain that priority date from the I-130 petition, and they will put that priority date on your I-360 petition. So for example, if your abusive spouse was a permanent resident and they filed a I-130 petition for you in the past, you can tell immigration that you are now filing an I-360 VAWA self-petition and ask to retain that priority date. And so they will then assign that priority date to your I-360 VAWA self-petition. And if that priority date becomes current, then you would be eligible to go forward with the I-485 instead of having to wait those years until the new priority date is current. The biggest bar to adjustment of status is admissibility. So in immigration law, everybody that applies for a green card has to prove that they are admissible. There are a variety of factors that can make someone inadmissible in immigration law. And these are the most common inadmissibility grounds that we come across. There are health-related grounds. All of these are found at INA section 212A. There are health-related grounds, criminal, security, illegal entries, such as entry without inspection, false claim to US citizenship, a previous removal order, and then aliens or non-citizens who are unlawfully present here in the United States. Previously, if someone was considered a public charge or subject to the public charge grounds of inadmissibility, they would not be eligible to apply for adjustment under VAWA, but that no longer is the case. Okay, so a VAWA self-petitioner who is applying for adjustment of status does not have to worry about the public charge grounds of inadmissibility. And if the only other ground of inadmissibility is that someone entered the United States without inspection, that does not prevent a VAWA self-petitioner from applying for VAWA adjustment. Okay, it's very clear in INA section 212A that a VAWA self-petitioner can apply for adjustment of status sorry, it's very clear under INA section 245A that a VAWA self-petitioner can apply for adjustment of status under INA section 245, despite the fact that they entered without inspection. If, on the other hand, they have entered and accrued unlawful presence and departed and then re-entered unlawfully, they may be barred. And so that's why we do very thorough legal screenings before we refer the cases out. And if you have any questions about that or about a case that you're working on, please just communicate that with us. We would hate for you to file something and then find out that the client is not eligible. There are waivers of inadmissibility for several grounds of inadmissibility, and most of those waivers require showing extreme hardship to a qualifying relative, either a U.S. citizen or permanent resident, spouse or parent, and in some cases to a U.S. citizen or permanent resident child. There are particular waivers that are only available to VAWA self-petitioners, which allow that self-petitioner to show hardship to herself or himself and or their children. Okay, so that is a whole lot of information. I'm 2 minutes over, so I don't want to take up any more of your time. I'm going to pass this over to Liz, but what I will do is I'm going to go through the questions and try to answer any questions that have come up, and then as if I see questions that would be helpful for the group, I'll try to raise those later.
Thanks, Trisha. There is a question on there, so you can go ahead. Meanwhile, I don't see the presentation anymore, actually.
Huh, there. I don't know when that happened, but I think is it there now?
Yes. Thank you.
While I was talking, I'm sorry about that.
No worries. Thank you. Okay,
Sure,
so I'll now be talking about some best practices when working with clients to prepare their VAWA case. There's going to be a lot of information here, so I might not be spending too much time on these slides. This whole presentation should be used as a resource for you all when preparing a case. Reference it as much as you need to. We'll be sending out handouts, the recording, and the actual PowerPoint itself as well after the presentation. And so you can go on to the next slide, Trisha. Thank you. So from the beginning, it's important to create a safe space for your client and use trauma-informed and client-centered practices. Because of COVID, some of these things may not be possible. So, such as meeting in person, for example, in a private room to talk. But I highly recommend that you all check out our initial client meeting handout to get some in-depth tips. And this is referencing to U-Visa cases in this handout, but it can also be applicable to VAWA cases. I'd also suggest to take a look at the document I'll send out with tips on working with clients remotely during COVID-19. You should be receiving all of these, like I said, after the presentation. And so before initiating a conversation with your client, you should confirm whether the client has a safe and confidential space to talk. Emphasize that they should let you know immediately if they can no longer talk. If children are home, which is often the case, ask what the client is and is not comfortable discussing while the children are there. If you need an interpreter, having one secured before you talk to your client for the first time will be essential in preparing the case and also building that safe space for your client and building that trust. NIJC also offers tips and a brief webinar on working with an interpreter. And so during your first meeting, it'd be a good idea to explain your relationship with NIJC. Although we do explain this when we sign our pro bono retainers, it's still important to reiterate to clients what everyone's role is, because at that point, the client has already received so much information, and we just want to make sure that everyone understands and we're all on the same page. In the first meeting, you can also explain the process of filing a VAWA application, the filing fees, if there are any additional documents that they might need to bring you. During our own screening process, we put together a referral packet with all the documents that the client has to start their case, but it's always a good idea to take time to review everything closely with the client to see if there's more pieces of evidence that can be included or excluded to strengthen their case. And we also have a sample list of documents in our manual appendices and other resources on our website that are readily available to you. I'll be also sending those after the presentation. And so additionally, setting up a good communication plan is crucial, especially for individuals in abusive situations or those that are not in secure locations like shelters. Ask them what their preferred method of communication is. We always make sure to flag if someone's home address is not a safe address, but a client might move around or circumstances may change. Maybe their abuser steals their mail or their cell phones are being constantly monitored. So it's good practice to ask things like, is it safe for me to leave a voice message at this number? Do you have a preferred address or has it changed? And stressing confidentiality is also important when trying to build that rapport with your client. Explain that you will not be sharing their information with anyone else unless they specifically grant permission to do so. A lot of people in general can have anxiety about their abuser or their family finding out about the case. Therefore, stressing that this is a safe and confidential space and creating this space for them will be essential. Also, most firms have their own release of information. So if you're working in a firm or your own practice and you have your own retainer agreement that you use, feel free to send that to the client as well. Something that might also come up during these client meetings is that the client might ask you questions beyond the scope of the case. For example, they might ask about counseling or tax assistance or other services. And so we do not expect you all to answer any questions as their pro bono attorney for questions that are beyond the scope of the case. And what you can do is just reach out to us, to Trisha and I, and we have many great referrals that we can send to you to provide to your client. And when working with your client on their affidavit, we recommend to use the power and control wheel as a tool to identify what types of power and control tactics their abuser use. It's also important to note that when starting to work on an affidavit, asking your client to reveal to you all of their personal details of the abuse they suffered will not be the best way to approach that conversation. You need to build up that conversation. Trust needs to be built. And so we do recommend you fill out your forms, get to know the client during your first meeting, and you can leave the affidavit work until after a few meetings, and then you can gauge your client's comfort level at that point. And I mean, essentially the difficulty in telling one's story is also compounded when having to use an interpreter. So keep that in mind. Some people might open up to you and others might have difficulty opening up at first, and that's okay. So we can move on to the next slide. And so the affidavit, this is going more in depth of what an affidavit should address. The affidavit serves as one of the most important pieces of evidence, and it should be written in the client's own voice. So if the client is comfortable and prefers to write their own affidavit in their own language, they can do that, so long as the affidavit is then translated and the translator signs the certificate of translation. However, we often find it very helpful to work on the affidavit together with the client. Then we review the affidavit together so that we can all ensure that all the key points are addressed and that the translated affidavit has been translated accordingly. And when explaining what an affidavit is to your client, you can describe it as an opportunity for them to tell their story and explain to immigration why they need this protection. And being able to tell one's story can be very difficult, but what can also happen is that it can allow someone to take control of their narrative, and that in itself is very powerful. We can move on. Okay, so here we list other forms of evidence that you will need. And these are identity documents of the client and their derivative if they have a derivative, such as birth certificates, marriage certificates. You will also be required to prove that the abuser was either a US citizen or legal permanent resident, as Tricia mentioned, and you can do so by submitting some of the documents listed here. So here we have US passport, US birth certificate, the child's birth certificate showing the place of birth of the abuser. Sometimes that happens and that's helpful. Sometimes the marriage license lists the abuser's status. Letters from family and friends with signatures saying how they know that the abuser was a US citizen or legal permanent resident can also be helpful, especially in instances where the client might not have as much evidence to prove that their spouse or partner was a US citizen or LPR. Okay, we can move on. And so additionally, proof of good faith marriage and joint residence with the abuser will be needed. You'll need to provide evidence that the marriage or intended marriage was entered into good faith, meaning that the self-petitioner must not have married their US citizen or LPR spouse solely for the purpose of obtaining immigration status. And so the most important factor in establishing a good faith marriage is providing proof that the couple intended to establish a life together at the time of marriage, and the self-petitioner must show that they resided with the abuser at some point as well. Some evidence can include the affidavit itself, where the honeymoon phase is explained in the beginning of the relationship, how they met, why they married. Marriage certificate can be used, leases that have both of their names, joint income taxes, bills in both names, bank account statements in both names, photographs of the family gatherings, wedding ceremony, etc. Letters also here are also helpful from family and friends. Basically any correspondence as well that the client can find that addresses both them and their spouse or their partner. And if the client or the abuser has been married more than once, they will also need to provide divorce certificates or death certificates for all prior marriages. In these sections of evidence, one has to get really creative in figuring out how to obtain some of these things, while also making sure that the client is not putting themselves in danger trying to retrieve any of these documents. We see that a lot of times coming up with this evidence is very difficult for someone, because if they fled their abusive relationship, they most likely weren't thinking of saving any documents for future use because they were thinking of survival. And so we have to work with clients on gathering these things. Okay, we can move on. And you will also be required to provide evidence that the client's current address is in the US and provide evidence that the client possesses good moral character. To prove current residence in the US, you can use utility bills, mail, rent receipts, again, letters of family and friends, or photo ID with an address. Evidence of good moral character can be included in the affidavit and also with letters of support from family and friends, or if they're very involved in their community, that would also be helpful. If they file taxes over the years, they can also include these. And it's always helpful to also include a local police clearance letter or state-issued criminal background check for all the places where the client has lived in for 6 months or more during the 3-year period before filing their VAWA self-petition. And if the client has been convicted of any crimes, certified criminal dispositions for all arrests are needed. Okay, next slide. Another component of VAWA requires that the self-petitioner show that they and or their child have been battered or have been the subject of extreme cruelty by US citizen or LPR spouse, parent, or child, right? And so evidence for this will also be in the client's affidavit, where the client documents not only the acts and behavior of their abuser, but also explains that they perceive those acts or behaviors as extreme cruelty. And so this is also where counseling is also very helpful. As Trisha mentioned, sometimes people might not see certain acts of abuse as abuse. And so it's not until one goes to counseling is that they're able to identify some of these things, and that could also be used in the affidavit. Police reports are also helpful if they ever did file a police report. It's not necessary, but if they do have it, that's helpful. Orders of protection, any certified dispositions for all criminal cases of the abuser, medical records if they ever had to go to the hospital or the emergency room because, after an explosion, letter from domestic violence counselor or a shelter, notarized letters of family and friends will also be helpful for this component. Okay, so now we're going to talk about filing procedures, fees, tips, and where to file. When filing the VAWA self-petition, you will need to prepare a packet with a detailed cover letter and index of documents, a G28, and the Form I-360, which is the self-petition, including evidence supporting all of the requirements. And if the client is eligible to apply for adjustment of status either at the time of filing their VAWA self-petition or later on when their priority date becomes current, you will be filing the adjustment of status application packet as well. And this would have its own packet with a cover letter, index of documents, G28, Form I-485 with 2 passport photos, and a fee waiver request, which is Form I-912 if the client is eligible for a fee waiver, or they can pay the fees with a money order. At some point, a medical exam will also be needed, which is Form I-693. Because the exam expires after 1 year and due to the high cost of getting a medical exam done, as well as delays in USCIS processing times, we recommend having the client wait to get the medical exam until they're scheduled for an interview, and they can bring the exam to the interview or submit it when it's requested if no interview is required. If applying for adjustment, you can also include an application for employment authorization with 2 passport photos, and this is the Form I-765 that will be based on the pending adjustment of status application. And let's say that there's no adjustment of status application, the client is only able to file the VAWA self-petition, that's all they're eligible for at this time that we see. You will have to wait, they will have to wait until their VAWA is approved in order to apply for employment authorization. Okay, next slide. All right, so filing fees. There are many forms that have a filing fee, so it's important to just always check the USCIS website for fees because they could change frequently. Thankfully, some forms do not have fees, such as the I-360, which is the VAWA self-petition. However, the Form I-485, which is the adjustment of status application, has a fee. We've listed here the fees, but again, you should check the website from USCIS for up-to-date information before you file. All fees should be in the form of a money order payable to the Department of Homeland Security if the client decides to pay this fee. And also a fee waiver request can be included in the application for both the I-485 and the I-765 using the Form I-912 if the client is eligible. Okay, next. And here are some filing tips. All foreign documents should be translated by a translator who certifies that they are competent in both languages. We have sample certificates of translation on our manual and appendices that you can use. Each packet should also be 2-hole punched at the top of the application and binded with metal prong fasteners or binder clips. You should not use spiral binding tabs or other exhibit markers. You should use page numbers instead. It's always good practice to double check that you are using the most recent version of the USCIS forms and submit appropriate fees. USCIS regularly updates their forms and fees, so be on the lookout for that. Know that you should also be preparing VAWA and adjustment applications as separate packets if that's what's going to be filed. This means that the I-360 will be its own packet and the adjustment application with employment authorization application in a separate packet. In the end, you can mail all these packets together in one mailing envelope to the Vermont Center using the FedEx or any other type of trackable delivery service. And in the next slide, we list the address of where you should be mailing these petitions. Next slide. And here is our last section of the presentation, talking about VAWA case processing. You should be receiving, after you file the VAWA self-petition, a notice of action indicating that USCIS, or the Vermont Service Center in this case, received the filing. And you should receive this notice in about 4 to 6 weeks after filing the VAWA self-petition. And it indicates when it was received, the exact date. And so, pursuant to current processing times, you should receive a decision in approximately 2 years or so. Processing times are regularly being updated at the USCIS website, so you can check that out for current processing times. And here we have the prima facie notice where on the face of the application, the Vermont Center sees that it appears that all the requirements have been met and the application appears to state a valid claim for VAWA relief. However, this does not mean that the petition has been approved. Essentially, this notice is important because it allows people to apply for various public benefits in the state of Illinois. If the client needs resources about how and where to obtain public benefits after they receive this notice, you can reach out to us and we can provide some referrals. Okay, so here we list the possible outcomes of the adjudication of the self-petition. So what could happen is that USCIS may issue an RFE for additional evidence, and they should allow up to 87 days to respond. You should carefully review the RFE for the deadline date. If your RFE response is insufficient or untimely, USCIS will likely deny the VAWA self-petition. Therefore, it's important that if you do receive an RFE, you contact NIJC immediately, and we can discuss a strategy and provide support as needed. If all goes well, then you should receive an approval notice for the I-360, as well as an initial grant of deferred action. And I will explain this more in depth on the next slide. In some instances, if we can go back to the previous slide, Tricia. Thank you. In some instances, you may also receive a NOID, which is a notice of intent to deny. They may issue a NOID if they determine that the documents submitted are insufficient. And it looks like we're actually running out of time, so I might just skip ahead actually. Thank you. All right, once you receive the approval, you'll receive the I-360 and the initial grant of deferred action. Deferred action protects someone from being placed in removal proceedings and allows the petitioner to obtain employment authorization. Something to note is that derivatives are not automatically issued deferred action. If there are derivatives, they will need to submit a request for deferred action upon receipt of the I-360 approval. So if any of this happens, reach out to us and we can give some guidance. And if the I-485 was concurrently filed with the I-360, the application will be transferred to the local district's office for an interview to be scheduled for adjudication. Okay. So for the adjustment of status interview, you should receive an interview after the VAWA self-petition is approved. Although USCIS does adjudicate the VAWA self-petition without in-person interviews, generally all applicants receive an interview for the application for adjustment of status. The majority of cases that we place with pro bono attorneys will receive an interview notice at the Chicago District Office. Please contact us if this happens once an interview is scheduled, and we can help you prepare. And these are some of the things that you can bring to an interview. If we want to skip ahead, it'll be important to keep in touch with your client. They should be notifying you if they divorce, get arrested, or if they're planning on moving, because USCIS needs to be notified in writing of this. And so you can check out the website for more information. And if your law firm moves, it's also important for you to file a change of address, and you must also notify NIJC, the Vermont Service Center. And I think that should be everything.
Yeah, I skipped ahead for we're skipping the case examples because we ran out of time, unfortunately. But here are the references for you all. And these are in the handout. And then the resources and next steps.
Right, so after this training, you should be receiving NIJC's email newsletter, where we post cases for pro bono representation that are available. I'll also send out all those handouts, links, everything you'll need to prepare a case if you're interested on working on a case with us. And feel free to reach out if you have any questions that we weren't able to answer here. And thank you for participating today. Also, please fill out the survey if possible. Here's the QR code. I'm also going to send out the link once I email everyone after the presentation. Thank you.
Yes, I'm so sorry that we ran over.
Yeah.
Please give us, it's just a lot of information that we want to give you all, but thank you very much. Thank you, Liz. And feel free to reach out to us if you have any questions.
Thanks, everyone.